everybody. My name is Nancy Delane, and this is How to Nurture Your Mind Child. And let's see. Go here. So tell me, what do you see? That's a question, Sue. What do you see?
I see a brain.
Okay, look a little more closely. What do you see?
Let's see. I see some little icons in the middle there.
Oh, you shouldn't see the little icons. Get rid of pretend the little icons aren't there. I'm doing this.
Okay.
Those are PowerPoint icons. Sorry about that.
No, that's
Look
okay.
at the brain. Does it look like a normal brain? I mean, do you see?
Oh, now that I'm seeing it, yes. Now I'm totally seeing
Yes.
that there's
Okay, so what are you seeing?
I'm seeing like little bodies. I see heads. I
You're
see
seeing like little
faces.
faces and little
Yeah,
bodies and little babies on the brain. Well,
absolutely.
these little babies represent child. So your mind child has got to be it's the product of your mind. And what I do with minds is I protect those mind children. Okay? I do it through intellectual property law and some business law as well. But uh, your mind child can take various forms. It can take the form of an invention. Okay, and if you're inventing something, you have constitutionally protected protection available to you. Specifically, you can get a patent. Or if your mind child can take the form of a work of authorship, whether it's a fiction or nonfiction, or you design something or you draw something, that can take the form of that. That's another form that a mind child can take, and that's covered by copyright, which is also constitutionally protected. Um, these things are protected in the body of the U.S. Constitution. They're protected under Article 3, Section 8, Clause 8. Okay? Congress shall have the power to promote the progress of science and the useful arts. They're not stuck off in some amendment like free speech is and freedom of religion is. These things are in the body, not in the amendments. So the founding fathers must have thought that intellectual property was pretty important. Okay? There are forms of intellectual property. They're not protected under the Constitution. Your business goodwill, which is your trademarks, your appearances. If you walk into some McDonald's, you know where you are. It looks the same. It smells the same. It is the same. It's a McDonald's. Okay, it's trade dress. It doesn't protect your proprietary information. Constitution protect your proprietary information, your trade secrets, but it does. These things are protectable under both federal and state law, and the federal law always has to have a constitutional basis, and they hang it off the Commerce Clause just in case you're interested. Okay, let's see, where are we here? Okay, but before you can nurture your mind child, before you nurture this mind child, you have to protect this mind child. So how can you protect your value? Okay, especially when it's registered or otherwise protected. The best story to illustrate value that most people are familiar with is there was a lady. She lived in Scotland, I believe, and was poor as a church mouse. I mean, this lady did not have two farthings to rub together, and she was a single mom, and she had a daughter, and she was just poor as a church mouse. And one day, she was sitting down, drinking a cup of tea, and a little boy walks into her head, sits down, and stays there. So she writes about this little boy, and she writes and writes and writes and writes and writes, and is now one of the richest people on the planet because she properly protected her intellectual property. Okay? Properly protected, your mind child has teeth. I mean, they're pretty big and they're pretty sharp teeth too, especially when they're registered or otherwise protected. And the best example of that, back in the early 2000s, the Record Industry Association of America was having a real field day with especially kids who wanted to download music. And there was a lot available on the internet for free. And you could just download all this stuff and download playlists and download this and download that. But what people forgot about was that this stuff was protected by copyright. So the Record Institute of America, the Recording Institute of America, and they did it with vengeance. They did it with a vengeance. And the kids would download great long playlists of copyrighted music protected by copyright, and people would get hit with lawsuits that just blew them out of the water. Um, and there was really no actual defense to those lawsuits because the kids had downloaded it. It was clear that the kids had downloaded it. The copyright was good. The download made an illegal copy of the music, and they settled. We settled a lot of those cases, and people learned not to play with the copyright law quite so much. Music became something that people actually pay that people got used to actually paying for. Okay. Okay. You can protect your invention. You can protect your inventions, your mind child, if your mind child takes that form, through two means. One of them is the patent, which is exclusively federal, and it's an exercise in disclosure. You have to disclose the best mode of making and using the invention when you write your patent application. Okay, but you can also protect it through trade secret, which is protected under both federal and state law, and it's an exercise in shutting up. Just keep your mouth closed, keep the secret, and the secret stays good. Okay. Copyright is also federal. It's protected through it protects works of authorship. And business goodwill, that's also a mind child. Okay, and that can take the form of your trademark. And an example of a trademark is what you're looking at. Okay, that brain that I pointed out before. If you look on that, next to that brain, there's an orange circle. That piece of that brain is my registered trademark. Okay, I walk my own walk, and it is protected under federal law because it is the mark that I use to define my business. I want people to see that brain and think of Delane Law Office. A more famous mark would be GE or 3M or IBM. Those are all famous marks as well. And you know what I'm talking about when I say GE or 3M or IBM. You are aware of what those companies do, what they sell, what they do. And another way to protect your mind child is through something called trade dress. That's the McDonald's example. If you walk into a McDonald's anywhere in the world, I don't care if it's in New York City, on the Ginza Strip, on the Champs-Élysées, in small town USA, they all look the same. They all have the same colors. They all have the same uniforms. They all have the same basic layout of the machinery. They all look the same. And they all kind of smell the same too. It's all McDonald's food. So that look and feel is also protectable. So when we get a patent, patents are kind of special things. Okay, they are things that can prevent others from making, using, selling, offering for sale, or importing the patent invention into the country that issued the patent. Okay, and the right to seek that patent protection is, as I said, guaranteed by the Constitution, but it only lasts for a limited time, and patents can't be renewed. And why would that be? If it's a constitutionally protected thing, the problem is that it limits free trade. It runs afoul of antitrust. So we compromise, and we get the antitrust to kind of back down for the patent for a limited time. Okay, after that, free trade kicks in, antitrust, the patent expires. You can't renew it. Okay. Also, there's no such thing as an international patent. There are patents that can be applied for under an international treaty, but there's no such thing as a global patent. It doesn't exist because each country issues its own patents under its own laws. And if you happen to go in under if you happen to want a patent protection in more than one country, you have to apply for patent protection in each country where you want that patent protection. Um, and there are three types of patents. Okay, most people think of the gizmo, the better mousetrap. Okay, but we also have plant patents, which are for asexually reproduced non-tuber cultivated plants. You can't get a patent on a potato. Do not ask me why. I do not know. Um, and you can't get a patent on a plant that just grows wild in nature, an uncultivated plant. You know, that's a product of nature. There are also design patents, and these things protect only the appearance. They don't protect the functional, the structural, or the utilitarian features of the invention. Okay, um, and there are four big requirements for patentability. Okay, first one is you have to have patentable subject matter. It has to be able to it has to be able to work. Okay, it's a process, it's a machine, it's some form of manufacture, it's some kind of composition of matter that does not occur in nature, or it's a patentable improvement of any of those things. Okay, you also you have to disclose the best mode of making and using the invention at the time of filing the patent application in such detail that a person of ordinary skill in the art in which that patent lies, somebody who basically does this, can take your patent application, look at it, go, okay, I can build it, and use your invention in the way in which you intended. You have to disclose that. Okay, the invention can't already exist in the form you disclose anywhere in the world, and it has to show a spark beyond just slapping a sticker on. It has to show some kind of actual improvement or actual invention. Okay, you can't just combine things and end up with a patentable invention. You have to have something that's original in your patent application. Okay. And as I said, where a patent is an exercise in disclosure, a trade secret is an exercise in being quiet, because trade secrets are just that. They're secrets. They exist as long as you keep the secret. Once you let the secret out of the bag, it's gone forever. Okay? And together with its value, it's gone forever. And it too can be used to protect inventions. And it works kind of interestingly in conjunction with a patent. Um, you can effectively extend your patent life by using it intelligently with a trade secret. Um, and it can protect company know-how. Those are your procedures, your processes, your business methods, all that stuff. You can protect your proprietary information, your contracts, your customer list, the price list, the things you don't want the whole world to know about. Okay. Um, Copyright, which protects works of authorship, is the easiest of all the intellectual property forms to register. Literally, the standard of copyright registrability is the work of authorship must be more original than the listing of names in the white pages of a telephone book. That's the standard. Okay. Um, and in order to copyright is a weird thing because according to the law, it affixes the moment your work of authorship is affixed in a tangible medium, meaning that when you first write it down, when you first sculpt it, when you first write down the music, when you record it, that work is copyrighted. But you can't enforce the copyright until you bother to register it, because the courts won't hear the case. They'll just chuck it out. Okay. Registration is pretty cheap. It's a standard copyright registration runs you $65 in copyright office fees. Obviously, if you have a lawyer do it, you're going to pay more than $65. But it runs you $65. The fee for registering copyright with the copyright office in the United States is $65. Okay, and the infringements have teeth. They have some serious teeth. you get what are called statutory damages, meaning you don't have to show that you were actually hurt by somebody infringing your copyright. You can just say they infringed my copyright. Give me $30,000, and the law says that if you prove your case, they'll do that. Okay, and if you can prove that this person infringed willfully, then you get treble that plus attorney's fees. So that's some pretty significant teeth, okay? Because litigation attorney's fees, they kind of add up. Um, okay, a trademark is any word, phrase, symbol, design, or combination of things that identifies your goods or services. Okay, it can be other things too. It can be a sound. It can be an odor. Um, because there are things that are trademark. The odor of Chanel #5 is a trademark, for example, um, and it gives the trademark owner the right to prevent others from using the same or a similar trademark for related goods and services without your permission. Okay, and it represents your business goodwill. If you want people to look at your trademark and think of you, preferably think of you kindly. Okay, um, and trademarks can be used without registration, but if you register them, then they're listed in the database. They give people presumptive notice of the existence of your mark. It's public notice. Um, and once registered, there is the legal presumption, if you ever go to court over it, that you actually do own the mark. Your registration certificate is sufficient for that. Okay. Um, and you can use that registration as your basis for filing for trademark protection under that mark in other countries. And it gives you the right to bring the lawsuits in federal court. Okay. And it also lets you record your mark with the customs folks, and thus prevent the knockoffs, or try to prevent the knockoffs from coming in. So, how do you turn all this into money? I mean, intellectual property is worthless unless you turn it into some money. Well, the easiest, in fact, the best way to do it for most instances is through licensing. Okay. This can be done with patents. You can license a trade secret. You can license a trademark. You can license trade dress. You can license a copyright. And thus, you have the users of your intellectual property or your mind child pay you for the privilege of using it, which is always a good thing. Okay, they pay you through royalties, they pay you through licensing fees. Um, you can limit these license however you want. It's a contract, it's nothing but a contract. You can write the law of the contract into the contract. It's fine as long as it's not, as long as it's not an illegal contract, you're good. So you can limit it in terms of the time the license is good for. You can limit it as to the territory. You can limit it as to the use of the mark or any variable you want in that particular licensing. But you have to be careful, especially with trademarks, as you um, as you write these license agreements, because if you exert too much power and control over another business, all of a sudden you've got yourself a franchise, and sometimes you don't want to do that. Okay. um, a franchise is kind of a special trademark use license. Okay, and it has three prongs. The first prong is that the franchisee does have the right to sell under the franchisor's trademark. The second one is that the franchisor has a good bit of dominion and control over the franchisee. They tell the franchisee what to do, how to do it. They don't run the business, but they have a pretty strong say in the business model. Um, and the third is that if you have an initial investment of over $600, that's a require. If it's less than $600, even if you have the other two factors, then you don't have a franchise. But it has to be an initial investment, and that initial investment counts over the course of about a year. Um, franchise are very heavily regulated, both in the federal system and in most states. And the feds require documentation to be supplied by the franchisor to the franchisee, the person who owns the franchise to the person who wants to get into the franchise. It's called the franchise disclosure document. It's this 23 section document that introduces the franchise or the franchise business model. It provides all the necessary information about the franchise. Okay. And then there's the franchise agreement, which is the contract between the franchisor and the franchisee that says this is how you're going to use the mark, and this is where you can use the mark. And it's the thing that lays out the limitations and terms and conditions and all that. Okay. And sometimes states require more documentation than that, and that varies from state to state. So you need to talk to somebody who is, if you're starting a franchise, either as a franchisor or a franchisee, this is not do-it-yourself law. Okay, this is not something you should be even thinking about doing it yourself. You need the lawyer for this one. Okay, and I can help. Okay, I provide counsel and advice as to which form or forms of intellectual property you have and you should protect. And there's IP that you should protect, and sometimes there's IP that it's just not worth protecting. Okay, I can help put those intellectual property protections into place. Even the patents. Yes, I have the patent ticket in my pocket. I can help you monetize that intellectual property through helping you develop those licensing agreements and developing that franchise. I can walk both franchisors and franchisees through the process. Your patents and trademarks for infringement. Okay. I've been doing this for over 40 years, and at least working with intellectual property. I've been a lawyer for about 20 years, but I've been working with intellectual property in one form or another for over 40 years. And feel free to give me a call at 518-371-4599. Any questions?
I don't think I personally have any questions right now, but boy, have you spurred some thoughts in my mind with what we all do.
That's good.
This is good. Excellent. And actually, if you want to, can you share your phone number again? Best contact info?
Sure. Phone number is 518-371. That's United States +1 518-371-4599.
Excellent. What an amazing presentation. That is huge. All those nuggets that you shared there. Thank you so much, Nancy.